Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Farrad Mosley, decided April 23, 2024. Opinion. Halligan, J. This case concerns an increasingly prevalent issue. When may someone who is not an eyewitness to a crime testify to a jury that the defendant is the person depicted in a photo or video? We hold that such testimony may be admitted where the witness is sufficiently familiar with the defendant that their testimony would be reliable, and there is reason to believe the jury might require such assistance in making its independent assessment. Here, there was no showing that the proffered witness was sufficiently familiar with the defendant to render his testimony helpful, or that the jury faced an obstacle to making the identification that the witness's testimony would have overcome. Accordingly, we reverse. 1. On June 10, 2015, police cameras in Syracuse captured a grainy video of a man running through the street and firing 3 shots into a van. The van promptly drove off, and the responding officers recovered 2 bullet casings but did not see the shooter. A grand jury indicted defendant Farrad Mosley for the shooting in September 2015, but the indictment was dismissed as legally insufficient. In July 2016, as the people were preparing to represent the charges against Mosley to a grand jury, an assistant district attorney showed the video of the shooting to Detective Stephen Kilburn. Kilburn identified Mosley as the shooter in the video and repeated his identification to a grand jury, which indicted Mosley. The trial took place in February 2018, and the key issue was identification of the shooter in the video. Though one of the van's passengers testified that he remembered the shooting, he said that he had not seen the shooter. And though an analyst testified as to the recovered bullet casings, she stated that they had not been tested for either fingerprints or DNA. The video therefore was the only evidence tying Mosley to the crime. At trial, the people played the video and relied on Kilburn to provide non-eyewitness identification testimony that he believed Mosley was the shooter in the video. Kilburn first testified as to his familiarity with Mosley during voir dire, out of the presence of the jury. Kilburn, a homicide detective, explained that he met Mosley on January 5, 2016, when Mosley was brought into the precinct as a suspect in a different crime. Kilburn thus estimated that by the time of the trial for the instant offense in February 2018, he had known Mosley for a year to a year and a half. When asked to describe his interactions with Mosley, Kilburn said he had sat in rooms with Mr. Mosley, walked side by side with Mr. Mosley, and had the occasion to speak with him, as well as having viewed both police-related and Facebook photos of Mosley. He estimated he had been in the same room as Mosley on a number of occasions, but gave only one specific date, January 5, 2016, the first date he could recall seeing Mosley face to face. He could not ever recall having street interactions with Mosley. He also specified that at the time the assistant district attorney asked him if he could identify the shooter in the surveillance video in July 2016, he knew that Mosley had been arrested on a warrant for a shots fired and weapons charge. The judge concluded that Kilburn had an extensive basis of knowledge to identify Mosley in the video. To avoid airing prejudicial information about other police interactions before the jury, the judge instructed Kilburn to avoid mentioning the unrelated criminal investigation for which he had arrested Mosley. Kilburn accordingly told the jury that he met Mosley about 7 months after the video was captured during his routine canvassing of the Syracuse neighborhood where the shooting occurred, had known him for about a year and a half, and that he had interacted with Mosley, walked with him, and spoken with him on a couple of occasions. He testified that he was familiar with Mosley's body language, body type, and build. He then viewed the video and identified the shooter as Mosley. He explained that though he did not know Mosley at the time of the shooting and did not know what Mosley had been wearing that day, he based his identification on his interactions with Mosley, his build, the shape of his nose, and on previously viewing the video and being able to zoom in and stuff. Though he referenced Mosley's nose, he conceded when shown screenshots of the video the face is a blur and there was no nose apparent at all. Kilburn also opined that Mosley's appearance had not changed, and that Mosley as he sits there now is the same as when I first encountered him, which is the same as he appears in that video. During deliberations, The jury requested to see the video again and a readback of Kilburn's testimony. They also requested and were denied a magnifying glass with which to view the video. The jury ultimately convicted Mosley of 2 counts of criminal possession of a weapon in the second degree, Penal Law Section 265.031b3, and reckless endangerment in the first degree. Mosley argues that the trial court abused its discretion in admitting Kilburn's testimony. The appellate division, with 2 justices dissenting, rejected this contention, holding that the people demonstrated Kilburn was more likely than the jury to correctly identify Mosley in the video. Because the people failed to establish that Kilburn's testimony would aid the jury in making an independent assessment regarding whether the person in the video was Mosley, we reverse. 2. We have twice before considered the admission of lay non-eyewitness identification testimony, in People v. Russell, and in People v. Sanchez. In Russell, the trial court allowed 4 lay witnesses: the defendant's roommate, his roommate's mother, his landlord, and a friend to identify the defendant as the person caught in surveillance photographs committing a bank robbery, People v. Russell. The people presented evidence that the defendant had disguised himself by growing an uncharacteristic beard that he sported during the robbery, and that he changed his appearance afterward by shaving it. Stressing 2 considerations: the personal knowledge that the witnesses had of defendant's appearance as of the time when the photographs were taken, as well as the fact that defendant had made the jury's task more onerous by creating impediments to identification. Russell, we held that the identification testimony was properly admitted. In reaching this conclusion, we referenced 2 federal cases, United States v. Robinson, and United States v. Farnsworth. Both of these cases construed Rule 701 of the Federal Rules of Evidence, lay opinion testimony, and focused on the 2 inquiries underpinning our conclusion in Russell: the extent of the witness's familiarity with the defendant, and whether the defendant had made the jury's job harder through use of a disguise or change in appearance. Similarly, in Sanchez we concluded that the admission of lay non-eyewitness testimony was proper because the proffered testimony was from 2 detectives who had known the defendant from prior occasions, People v. Sanchez, and it was undisputed that the defendant's appearance had changed between the crime and the trial, Sanchez. Due to the widespread deployment of surveillance in public spaces and the ubiquity of private cameras and video recording devices, lay opinion identification testimony has become an increasingly common form of evidence. See George Bach, Moderating the Use of Lay Opinion Identification Testimony Related to Surveillance Video, Tracking the Multifold Increase in the Annual Average of State Cases Discussing Lay Opinion Identification Testimony Related to Surveillance Video Since 2010, Bennett Capers, Crime, Surveillance, and Communities, Tracking the Expansion of Surveillance Technology in New York City. Correspondingly, lay opinion identification testimony and the issues surrounding its admissibility have garnered increased attention from courts around the country. See for example State v. Gore, State v. Sanchez, Glenn v. State, Lenore v. State, People v. Thompson. We first note that, despite the increasing prevalence of lay non-identification eyewitness testimony, its use presents several challenges. Courts have historically been wary of lay opinion testimony, which may usurp the fact-finding function of the jury, United States v. Garcia. Although use of such testimony may be warranted in certain circumstances, courts must be vigilant that the testimony does not unnecessarily invade the jury's role. See United States v. LaPierre. Though sometimes permissible, the lay witness identification ran the risk of invading the province of the jury. See also Krulak v. Nationwide Mutual Insurance Company, in the context of expert testimony, noting testimony that intrudes on the province of the jury to draw inferences and conclusions is improper absent jury handicap. Trial testimony by a law enforcement officer may pose additional concerns by drawing attention to a defendant's prior interactions with the police, and efforts to mitigate any prejudice by omitting reference to a law enforcement officer's occupation or providing a cryptic basis for familiarity may constrain the opportunity for vigorous cross-examination. See Russell. See also United States v. Walker, United States v. Pierce, United States v. Calhoun. Whether the probative value of such identification testimony outweighs these drawbacks is a decision committed to the sound discretion of the trial court, and reviewable by this court for abuse of discretion. As we held in Russell, The relevant question is whether the proffered testimony serves to aid the jury in making an independent assessment regarding whether the person in the surveillance footage was indeed the defendant. To answer in the affirmative, there must be some basis for concluding that the witness is more likely to correctly identify the defendant from the photograph, or video, than is the jury. Farnsworth, see also Russell. We did not elaborate on the contours of this inquiry in Russell or Sanchez. Most other jurisdictions that have considered the question apply a totality of the circumstances test, considering whether the witness is familiar enough with the defendant that it is reasonable to believe their testimony would be helpful and reliable, and whether there is reason to believe the jury might require that assistance. See for example Gore, Surveying Cases. Our review of these cases, as well as the cases arising in the appellate divisions, indicates that the issue of lay non-eyewitness identification testimony arises in a variety of circumstances and often requires courts to make fact-intensive determinations. Accordingly, we too adopt a totality of the circumstances test, which preserves the discretion of the trial court, the court that, being closest to the facts of the case, is in the best position to make these evidentiary decisions. We note that this standard is fully consistent with our reasoning in Russell and Sanchez and the underlying appellate division opinions that we affirmed in those decisions. First, the court must determine whether the witness has had sufficient contact with the defendant to achieve a level of familiarity that renders the lay opinion helpful. United States v. Fulton, citing United States v. Beck. If the witness lacks such familiarity, it is the province of the jury to draw its own conclusions regarding the identity of the person depicted without the witness's assistance, Commonwealth v. Vacher, and that is the end of the inquiry. In making this assessment, courts may consider the witness's general level of familiarity with the defendant's appearance. Russell, see also Gore, Thompson, United States v. Dixon, Pierce, Robinson, and whether the witness's familiarity spanned an extended period of time and variety of circumstances. Russell, see also Gore, Sanchez, Walker, Beck, Pierce. Courts may also take into account whether the witness was familiar with the defendant's appearance at the time the surveillance footage was taken. Russell, see also Gore, Thompson, Sanchez, Walker, Beck, Farnsworth. Also relevant is the witness's familiarity with the defendant's customary manner of dress or clothing on the day of the surveillance footage. Russell, see also Gore, Thompson, Beck, Dixon, United States v. Jackman. Along similar lines, courts should also consider whether the witness references a specific trait the defendant has, such as a distinctive gait, scar, or tattoo, and importantly, whether they identify that trait in the surveillance footage. United States v. Williams, identification based on style of walk. The second consideration is whether the jury needs the witness's assistance, see for example Fulton, Vacher. Here, courts should consider whether the defendant's appearance changed between the time of the surveillance footage and the trial or whether the defendant disguised himself in the surveillance footage. See Russell, defendant sported an uncharacteristic growth of facial hair the day of the crime and shaved immediately after. See also Gore, Sanchez, Thompson, Beck, Dixon, United States v. White, Jackman, Farnsworth. In addition, courts may consider the quality of the surveillance footage and the extent to which the subject is clearly captured in the frame. See for example Gore, Thompson, White, Dixon, Jackman. Where an image is clear enough that is, not so crystal clear that the jury could identify a person as capably as any witness, and not so obscure that no witness could readily identify the individual, this factor may weigh in favor of admission. See for example Gore, quoting Jackman, Sanchez, Fulton. Finally, we note that before admitting lay non-eyewitness identification testimony, a court should inquire as to the basis of the witness's familiarity outside the presence of the jury in a separate hearing or voir dire, as the court properly did here. The party offering the witness, in most cases the people, bears the burden of establishing that their testimony would both be helpful and necessary. We note, however, that it is incumbent on both parties to create a thorough record to aid the court in its determination and to allow for meaningful appellate review. Additionally, as a best practice, it would be appropriate for the trial court to provide cautionary jury instructions, both at the time of the testimony and during the final charge, explaining to the jury that lay non-eyewitness identification testimony is mere opinion testimony that they may choose to accept or reject, and reminding the jurors that because they are the finders of fact, it is their opinion as to whether the defendant is depicted in the surveillance footage that matters. See Sanchez, noting that the trial court issued appropriate limiting instructions to the jury. People v. Lee, noting court's repeated instructions reminding the jury that it was its function to determine who was depicted on the video. People v. LaRock, appropriate limiting instructions given both during testimony and the court's final charge. 3. We now turn to the case at hand and conclude that it was an abuse of discretion to admit Kilburn's testimony. First, the people did not establish that Kilburn was sufficiently familiar with Mosley to render his identification helpful to the jury. When addressing this issue during voir dire, Kilburn testified only that he had sat in rooms with Mr. Mosley, walked side by side with Mr. Mosley, and had the occasion to speak with him. Though Kilburn represented that he had interacted with Mosley a number of times, he failed to specify how many times, for how long, or what the nature of those interactions were. Indeed, it is unclear from the record whether Kilburn interacted with Mosley on more than one day. See People v. Mosley, characterizing Kilburn as having recalled only a single day on which these interactions took place. Though Kilburn also referenced looking at photographs of Mosley, this is not a proper basis for familiarity. See Pierce, see also Sanchez, LaPierre. Far from having interactions with Mosley in a variety of circumstances, Kilburn testified that he had never had street interactions with Mosley, and it is unclear whether he ever interacted with Mosley outside of the police station. Kilburn was not familiar with Mosley's appearance at the time the shooting occurred. He did not meet him until 7 months later. Nor did Kilburn know what Mosley was wearing on the day of the shooting. Moreover, Kilburn did not connect any distinctive traits of Mosley's to the person depicted in the surveillance photo. Before the jury, Kilburn stated that he was familiar with Mosley's build, body language, body type, and the shape of his nose. Contrary to best practice, though, the people did not elicit these grounds for familiarity before the judge when laying the foundation for the admission of Kilburn's testimony, which would have avoided potential prejudice and allowed for robust cross-examination on that foundation. Even aside from this point, the assertions failed to support the utility of Kilburn's testimony. Kilburn did not specify what is unique about any of Mosley's features, or connect those features to his identification of the image in the video. Indeed, when asked to look at a screenshot of the video, Kilburn acknowledged that due to the poor quality, there was no nose apparent on the captured face at all. Second, the people failed to demonstrate that the jury needed Kilburn's help. The shooter in the video did not wear a disguise, and there is no indication that Mosley's appearance changed. If, as Kilburn testified, Mosley as he sits there now is the same as he appears in that video, there was no reason to think that the jury would not be equally well positioned to identify the defendant based on his appearance in the courtroom. As for the surveillance footage, the testimony tends to suggest that the quality of the video here would make it difficult for anybody to reliably identify the subject. Kilburn testified that stills of the video were so blurry that it was impossible to make out a face, and that his identification was based on being able to zoom in and view the video multiple times, which, rather than establishing that he was better equipped to identify the defendant in the surveillance footage than the jury, demonstrated that his identification was largely based on exactly the same evidence that the jury had before it. In short, there was no basis to conclude, based on the totality of the circumstances here, that Kilburn would be more likely to correctly identify the defendant from the video than the jury. The admission of Kilburn's testimony in this case illustrates the challenges of cross-examination inherent in lay opinion identification testimony from law enforcement. For example, during voir dire, Kilburn testified that he could not recall ever having street interactions with Mosley. Yet to avoid prejudicing Mosley at trial, at the judge's instruction, Kilburn told the jury that he knew Mosley from canvassing in the area around where the shooting took place. Not only did this statement overstate Kilburn's familiarity with Mosley by implying that he had interacted with Mosley in more natural settings, but the defense was unable to thoroughly cross-examine Kilburn about this aspect of his familiarity. As other courts have acknowledged, the choice between full cross-examination and possibly revealing the defendant's criminal history is a difficult one. Farnsworth, And so we too caution trial courts to admit this kind of identification testimony only in limited and necessary circumstances with all appropriate safeguards. Pierce, see also Russell, United States v. Butcher. Finally, the error in admitting Kilburn's identification was not harmless. We start by asking whether the evidence is overwhelming in the first instance, because unless the proof of the defendant's guilt, without reference to the error, is overwhelming, there is no occasion for consideration of any doctrine of harmless error. People v. Myrina, quoting People v. Crimmins. Here, the evidence is far from overwhelming. The only evidence tying Mosley to the crime was the low-quality video and Kilburn's identification testimony, see People v. Mosley. Without Kilburn's testimony, the people presented no more evidence than they did in their first indictment, which was dismissed for insufficient evidence. The error thus cannot be deemed harmless and requires reversal for a new trial. Accordingly, the appellate division order should be reversed and a new trial ordered. Order reversed and a new trial ordered. Opinion by Judge Halligan. Chief Judge Wilson and Judges Garcia, Singas, Canataro and Barros concur. Judge Rivera concurs in result in an opinion. Judge Troutman took no part. Decided April 23, 2024.
Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law